Welcome to this Expert Voices event on using deferred sentences. One of the measures being introduced in the sentencing bill is the extension of the maximum period that a sentence can be deferred from 6 to 12 months. And we want to look at creative use of deferred sentencing. For this seminar, we are very privileged to have three excellent speakers who will speak for roughly 15 minutes each, leaving ample time for a Q&A at the end. Firstly, we will hear from Professor Julian Roberts, currently at the University of Oxford, and Executive Director of the Sentencing Academy and a former member of the Sentencing Council from 2010 to 2018. Julian will give a brief overview of the concept and context of deferral in England and Wales. We will then hear from Sheriff Shona Gilroy. Shona was appointed as a sheriff nearly 9 years ago and has always sat in Glasgow Sheriff Court, where she oversees the array of civil and criminal business. Before that, Shona was a career prosecutor at the Crown Office and Procurator Fiscal Service for 26 years. Shona will talk about the use of structured deferred sentence as a tool or quasi-disposal in Scotland, using her experience in Glasgow's Women's Court as illustration, and will compare this with the use of deferred sentencing generally. Finally, we will hear from Sergeant Sandy Thompson from West Midlands Police. Sandy designed and ran the crime-free programme for the West Midlands Police and their partners after a long and arduous battle since 2018. Sandy will outline how the use of deferred sentences allow problem solvers to increase the use and effectiveness of restorative justice for victims, increase victim satisfaction within the criminal justice process, and work with defendants to coach them towards the successful completion of community-based punishments. After we've heard from each of these speakers, I will open up the Q&A. Again, please submit your questions throughout the event on the Teams Q&A function, which you can find at the top tab, ready for this session at the end. We hope you enjoy. So over to Julian.
Thank you very much. Good afternoon, everyone. If you could just bring up the slides. And on to the next, or the first substantive slide. Thank you. So I'd just like to provide a bit of an overview of deferred sentencing. I'm focusing on England and Wales. The experience in Scotland you'll hear about shortly, and it's in many respects more interesting and fruitful than the experience down here, at least at the current time. But I'd like to provide a slightly broader conceptual and possibly academic perspective on the issue. So first of all, I'll talk about what deferred sentencing is. It comes in many different forms, as you might expect. I'll address the reasons why a court might defer rather than impose sentence immediately. Note that this is actually not a uniquely English sentencing option or even one restricted to the United Kingdom. Most common law jurisdictions allow courts the power to defer sentence for a prescribed period. And I'll talk about some of the potential benefits and I suppose some of the downsides or potential threats contained in deferred sentencing. So if I could go to slide 3, please. Now, in England and Wales, the key provision of the statute, as you can see, is here. It enables a court the deferral period, which is limited at the present time to 6 months. Enables a court, as you can see, to examine the offender's conduct, changes in their life and so on, between the conviction and the ultimate sentencing date. And this period will give the offender an opportunity to take a number of steps that they should reasonably take to change their life style, to change their risk of reoffending, possibly to make reparation, as you can see, which is an explicit reference in the statute, make reparation to the victim. And so that's what it's all about. It's about pausing the determination of the sentence that will be ultimately imposed to afford the offender an opportunity to do something, to change something. And I think that's important to note because, in a sense, the sentence that any court imposes is designed to change something, to address the offender's problems or to rectify circumstances which have led to the offending. So the deferral period, limited to 6 months in this jurisdiction, is there, in a sense, to do what the sentence will be doing in many other cases. The 6-month limit in England and Wales is quite anomalous. It's much longer in other jurisdictions. A typical norm is 12 months, but some jurisdictions have an even longer maximum deferral period. And the deferral period is important because if it's endless, then this matter will be hanging over the court caseload, of course, and the offender's head and so on for a long period. But if the deferral period is too short, then there's insufficient time for the offender to take the necessary steps to achieve the kinds of progress that will result in a different sentence being imposed. So at the Sentencing Academy, and along with City University and Gemma Burkett, we've been doing research on the deferred sentence, and we have thought for a long time that the ceiling should be increased from 6 months to something higher, 12 or 18 months. And we're happy to see that in the current sentencing bill, which is proceeding through Parliament, currently in the House of Lords, will raise the ceiling on deferral from 6 months to 12 months. So what kinds of cases are we talking about? Well, we're talking about cases where the defendant may have a substance abuse problem which needs addressing. The defendant may wish to make voluntary reparation to the crime victim. The defendant's circumstances may be changing. He or she may be completing a treatment or rehabilitation program. They may be completing some professional or university training and so on. And the immediate imposition of a sentence would be hugely disruptive. This is another reason for imposing or allowing the deferral period to take place. And there's quite a range of defendants who could potentially benefit from this deferral process. I'll give you a practical example. There's an Oxford student, actually, a medical student who had a very serious substance abuse problem, and she was convicted of wounding her boyfriend, who was another student. And she was looking at a term of immediate imprisonment had she proceeded to sentencing following conviction. The court, in her case, deferred sentence for the statutory maximum of 6 months, and during that period she undertook drug treatment and took a number of other steps. And when she returned to court, quite a different person in the view of the court, it's important to note. The court imposed a suspended sentence order rather than the immediate term of imprisonment that would have been imposed. So that's a second sort of critical element in the deferral consideration. If the court is looking at some kind of community order with requirements, probably a deferral would be unnecessary, because the community order can permit the offender to take various steps to reduce their risk and so on. The deferral option is particularly useful if the defendant is facing a term of immediate imprisonment, and if during the period of deferral, 6 or 12, whatever it happens to be, they can take sufficient steps to permit the court to impose some other sanction other than immediate imprisonment. So it wouldn't make much sense for the defendant to have sentencing deferred for 6 months and then to come back and to receive the sentence that would have been imposed anyway prior to the deferral. So that's what we're talking about. We're talking about defendants whose lives are in flux, whose circumstances are changing, and who may benefit from the opportunity to do something about their future, as it were. If I could go to the next slide, please. So key elements of the deferral period: the offender must consent to the order. Now, some defendants want to proceed immediately to sentence and may not want to undergo this option. The offender must comply with a set of requirements. And this is important. The court will stipulate a series of requirements which may relate to drug treatment or alcohol treatment, and so on, or they may sort of be requirements which involve restoration or reparation. And again, if there is a restorative justice component, of course, the deferral period does allow the possibility of a meeting, possibly, or some kind of interaction or communication between the offender and the victim, assuming that both parties, as it were, wish to engage in that process. The court must be satisfied that the deferral would be in the interests of justice. That seems like an obvious sort of element, but one of the sort of dangers of deferral sentencing, or one of the issues that's been flagged for our attention in our research, is the possibility that some defendants of a particular profile may benefit differentially. The case I mentioned of the Oxford medical student, a number of tabloid newspapers cast that as a court going easy on an elite student from a relatively wealthy background, it turned out, and so on. So it has to be clear that there is no advantage being conferred on particular profiles of defendants, and that deferral is an option, like any sentencing option, which should be available across the board. And I've noted the 6-month maximum deferral period, which, as I say, we're happy to see is about to rise to 12 months in the event that the legislation passes as currently drafted. If I could go to the next slide, please. Candidates for deferral. Well, anyone starting or completing some kind of training or treatment program, I mentioned that, and there are many defendants whose life circumstances are in transition and which are likely to improve in the near future in a way that will change the court's view of the appropriate sanction or of the defendant. And although to date there's been a relatively narrow application of deferred sentencing in England and Wales, this wasn't always the case. If you go back to its origins in the early 70s, there were, in the first decade or so, about 10,000 cases deferred every year. Now you may say, well, how many today? And we don't really have a good handle on that, because the ministry, as far as we can tell, doesn't record the number of deferrals or the success of the deferrals. But our best estimate is there are about 1,000 cases deferred every year across England and Wales. And we've always thought that at the Sentencing Academy that the range of deferrals can expand, as can the volume of deferrals imposed. We think that there is a real opportunity here for reducing the use of imprisonment in a principled way, but obviously one has to be careful with this provision. And if I could just go to the next slide. So what's the potential of this provision? Well, first and most obviously, there is the potential ability to reduce the use of immediate imprisonment. That, of course, I don't need to say, is a major priority in England and Wales right now and many other jurisdictions. And if a defendant who's looking at an immediate prison sentence, presumably a relatively short one, can undertake the necessary steps to change their circumstances to permit the court to impose a non-custodial, a suspended sentence order or a community order with requirements at the end of the deferral, it surely makes sense to pause the sentencing exercise, give the offender an opportunity, stipulate the requirements that would be needed to be fulfilled in order for the immediate imprisonment to be replaced by non-custodial sanction, and so we feel that there is the potential to contribute to reducing the number of immediate prison terms, particularly short ones in England and Wales, and they're of course the ones that are of most concern. If you've got a period of deferral, and particularly if it's 12 months, there clearly are more opportunities for restorative justice encounters, for the exchange of views and information, potential for a greater use or incidence of reparation to the crime victim. And I suppose the last sort of potential benefit that I'd really like to stress is, most sentencing hearings, the court imposes a sentence. The courts, of course, explain the impact, the consequences of their sentence for the benefit of the offender in open court, and their legal advisor will, further describe. But it is obviously a rather top-down approach. With deferral, the court or the state is effectively transferring some agency to the offender. The offender is being incentivized. So rather than simply saying, okay, you're going to go to prison for 6 months, and here are the conditions and so on. What we're saying to the offender is, you now have effectively a last opportunity. You're looking at an immediate imprisonment sentence, but if you take these steps, if you comply with these requirements and conditions, we will reconvene in court 6, 8, 9, whatever months later. And in the event that you have made sufficient progress, then you will have, in a sense, earned your way out of imprisonment into a lesser sanction. And if the offender has made this progress, as I say, I think it's important and beneficial, because without the period of deferral, the sentence is aiming at exactly the same moral moral transformation and progress towards rehabilitation. So I'll just put up one last slide because I've run out of time, I think. If you need further information, there's an academic paper there, and a recent publication, a joint publication, the Sentencing Academy and City University, will give you a broader view. And if you have any questions, feel free to just contact me about any aspect of this presentation. So thank you very much, and I'll now hand back to the organisers.
Thank you, Julian. That was great. So I'm now going to pass you over to Sheriff Shona Gilroy.
Okay, thank you very much. Good afternoon, everyone. So my brief today is to talk about the use of the structured deferred sentence in Scotland, albeit I caveat that with I can only speak about Glasgow Sheriff Court because that's where I've always practiced. And to give this some context, I will touch upon the use of this option in the Women's Court in Glasgow. So I think it's important I give you some information about the operation of that court. And it's probably also helpful to get a brief summary about my career and experience. I should probably outline firstly that we have a number of problem-solving courts in Glasgow, which is often cited as the busiest court in Europe. No idea whether that's correct or not. And as a judge, I've sat in each of these problem-solving courts. And the sheer volume of cases in Glasgow and the condensed nature of an urban court, I think, gives us the opportunity to convene these specialist courts. So we have a young person's court, really dealing with offenders under the age of 21. We have a drug court, which will often use structured deferred sentence to assess an accused's ability to progress to a drug treatment and testing order. We have an alcohol court, extremely busy, as I'm sure you can imagine. And then we have the women's court. Now, when I was a prosecutor, I was often aware that who I was prosecuting this week had, in fact, been the victim last week. I spent a great deal of my career at Crown Office working on policy and legislation as it affected victims and vulnerable witnesses. And I did a great deal of work on the prosecution approach to rape and domestic abuse. So it'll be apparent that led me to work a lot with third sector organisations advocating for issues particularly affecting women. So I suspect that's why I was selected to set up the Women's Court. As a judge, though, here in Glasgow, I do the full range of work. That includes sitting in the family court, dealing with child contact orders, dealing with civil disputes, presiding over criminal trials, including jury trials where I can sentence up to 5 years in prison. I take referrals from the Children's Reporters Agency where it might be allegations of child offending or parental neglect. So I deal with the whole spectrum of cases. But I think firstly what I need to do is distinguish the structured deferred sentence that I'm going to come on and describe to you from the use of deferred sentence in the courts in Scotland generally. I should confess a level of ignorance about the community disposals available in England and Wales. So I was listening very carefully to what Julian was saying there. When I Googled deferred sentence in England and Wales, I found that the court will state what the sentence would be if the conditions attached to deferred sentence are met, and if they're not. Whereas in Scotland, a deferred sentence comes with an element of suspense. I can keep my powder dry. I don't have to declare what sentence I would have imposed, nor what non-compliance will bring. So I would tend to use a deferred sentence where there's been a plea or a finding of guilt, and it's an offender that I suspect might not reoffend or perhaps has little or no record. It's an offence itself which is fairly low level, if I can describe it thus. Or it might be quite similar to what Julian was saying there. The offender was recently placed on a community order and I want to test their cooperation with and performance in that order. Or it might be somebody who's already serving a prison sentence and I want to use this case to oversee their transition back into the community upon liberation. So I would defer sentence to a specified date with the overriding instruction that the offender be of good behaviour. I would make clear that a report from the police will be provided at that later date, at which point I can assess the whole picture. And if they are already on another community sentence, then if that involved social work supervision, I would order a progress report, as I say, so that I'm fully informed about the offender's current situation at the date of deferred sentence. So in practice, I often use this too for those kind of low level, perhaps neighbourhood disputes or sort of situational domestic cases that I suspect, or the information is that it's an isolated incident. I perhaps impose or keep alive special conditions of bail to protect the complainer, so that I view this as a sort of a cooling off period, and warn that there must be no recurrence. I'll tell the accused that if I'm informed that they've been of good behaviour at the end of the period, then I suspect I'd be able to deal with the case leniently. It might be that they're simply admonished. So it is a bit of a sword of Damocles, and usually I'd select a duration of between 3 and 6 months for cases in that cadre. On the other hand, then, if I can come on to describe the structured deferred sentence, it will involve active social work involvement during the period. It isn't a wait and see. Rather, it is imposed with an expectation of work and engagement on the part of the accused. And in the scale of disposals that will be examined in a pre-sentence report by social work, a structured deferred sentence is deemed to be more flexible than the supervision that comes with, for example, a community payback order. And it's more flexible in terms of appointment arrangement, the location of appointments, and the programme of work set out. It can be considered, I think, by social work sometimes to be less intense in terms of addressing the offending behaviour in appointments. The primary purpose is to solve the problems that influence the offending behaviour or that inhibit the ability to be of good behaviour. This is all about getting somebody on the right track. So what I see a structured deferred sentence as providing is literally problem solving to allow us to get to the stage that the roots of the offending can be addressed. I see it as testing an accused's ability and willingness to engage with workers and programmes, and fundamentally it allows a close eye to be kept on the above. So if the offence or the offender requires it, perhaps after a period of structured deferred sentence with that problem solving element, it might be then that a community payback order is imposed for maybe 12 months with an element of supervision, depending on the work that it is assessed requires to be addressed with the offender. The report by social work produced to assess sentencing options in general will identify for me, the sentencer, what a structured deferred sentence could address and set out a plan for doing so. And most often what I see is that that involves addressing housing, drug stabilisation and any preliminary addiction work, including external residential rehabilitation programmes. It might include access to benefits, and it will also likely include immediate health screening. So let me talk a little bit then about its use in the Women's Court. It's been in operation since January 2023. I held preliminary discussions with social work to identify aims of the court and admission criteria, and what the supports that the team allocated to it could provide. At first it was just me, but then another sheriff was brought on board, and the court sits twice a month. It's an all-female team across both the bench and the social work staff, and I consider that to be important because the vast majority of the women that I see are victims of male violence and exploitation. So broadly, we agreed the following criteria for the court. Firstly, there's a geographic element. The accused requires to be resident within the jurisdiction of the court. Secondly, the offending is trauma-related. And thirdly, the approach of the court and the support it directs must be trauma-informed. And finally, the offender is cooperative and ready to engage. So for Glasgow residents, they are directed to the service Tomorrow's Women, and this is a dedicated, co-located team of social work and other services. So it has attached to it a general practitioner and a community psychiatric nurse. So there's the ability to prescribe medications, including opioid replacement therapies, linking in with addictions workers. It can on site do drug testing to support DTTOs. And then, of course, there's general health and sexual health screening, and to identify mental health requirements. So the team links in with housing agencies, homeless charities, benefits agencies, and others as necessary. As well as individual consulting areas at the centre, they hold therapeutic group work and classes. So there could be things such as cookery and other life skills, and at times they've brought in theatre groups to do work on the likes of self-esteem, conflict situations, and so on. So for me, the benefits of this service that's provided to the court via Tomorrow's Women is that we have this package of holistic care with so much under one roof. But they also have the ability to be flexible. They do outreach work. They go to the offender. A good number of our cohort have overwhelming anxiety, find it difficult to leave the house. And there's a huge emphasis on safety. It's a big priority because I can tell you in the number of years that I've been doing the court, I have seen so many overdose deaths, suicides, and we had one horrific murder of a woman that was admitted to the court. It's important to note that whether an offender is on a structured deferred sentence or a community payback order involving supervision from what I might describe as a mainstream court, not the women's court, they are seen and supported by the same services and social work teams. So the question then becomes, what is it that the women's court brings that is additional? Well, we try and make it seem like a good result to be admitted to the court, that this court approaches things slightly differently, and it's a chance to get support and leave offending behind. And I find the lawyers are very supportive of this. So the expectations of the court are laid out for the women. I always explain that I will be speaking to them direct about their compliance and about issues that arise, that I expect honesty and transparency and so on, and that I expect them to speak to me. Their lawyer steps aside, literally. And so if you're discharged from the court for non-compliance, then sometimes I will really try and make them feel my disappointment that I'll voice. So what is it that we try and do differently? I am not suggesting that any of this is rocket science for sentencers and those interested in the exercise. But what we do try and achieve is very close engagement. So the offender must appreciate that they are required to attend frequent appointments. It might be as many as 3 a week with the team and any follow-up agencies that the team identify. They must attend court for reviews every 4 weeks with consistent judicial oversight. And there are pre-court meetings that I hold with the social work team to firstly select who's eligible for admission to the court and then to discuss the progress of entrance. Of course, it may be that there are just too many obstacles and now is not the right time for that particular woman. What are my sentencing options then? Well, they can be very limited. And it's a question for me as well, whether I sentence somebody who is not cooperating or is not eligible there and then in the court, because I can tell you the mood in the room really shifts. Quite often I will assign a 9:30 hearing for me before normal court starts, if you like, and sentence the individual then. But to emphasise, for me, one of the most important parts of the model is the pre-court meetings with the team. It is in open court and in theory anyone can attend. It's informal. I'm sitting in civilian clothes at the table with social work, and they will amplify or explain what is summarised in the court reports, whether that's as regards eligibility for admission to the court in the first place, or for those women already subject to a structured deferred sentence, to expand on the review report prepared for court. But crucially, they will share with me any insights, any feedback from the women, what they're struggling with, and what I might highlight to motivate or to congratulate. So I'm trying to get to know the women before me and what incentivises them, or what obstacles they are reporting, and therefore what problem solving might need to be adjusted. So it is invaluable to me to learn all of this. There'll be material, of course, that the women do not want shared in open court, and I respect that. I'll find ways to allude to what is going on in their lives and to encourage them to engage with the supports to tackle those issues. And I recognise and I emphasise all the small successes. It might be that they have social work have granted them contact with their children, things like this, and I can reward in some cases as we go along as well. And another important aspect of the pre-meetings is to share the acute safety issues, and if there is a relationship ongoing, that status and whether that brings any elements that I need to be cognizant of. It can persuade me to keep an order going which might otherwise feel hopeless. The team really advocate for the women. I thought it might be helpful to end with some of the issues, if you like, that I struggle with in the court. I think it's an issue to try and maintain the credibility of the court in terms of who to admit and then when to let somebody go. It can be really hard to say no to someone and say that they're not eligible to come into the court. But I'm not going to admit somebody on road traffic offences just because the social work author has referenced a domestic incident 20 years ago. So there's a balance to be struck. I am sometimes persuaded to keep the order going because safety concerns are so acute. And this is at least a means of a service knowing that a woman is alive. I am very aware that I am therefore, the court is not engaging in any rehabilitation or anything therapeutic, but I do take the view that needs must. And the issue of credibility includes non-attendance at court and the decision to issue a failure to appear warrant when somebody doesn't attend. And then I have a decision as to whether I readmit them to the court once I've heard their explanation, once they've appeared on the warrant. But how many failures to appear do I allow to go? How many failures to attend appointments with the team and with other supports? And I'm acutely aware that there are other new entrants sitting at the back of the court listening to this, and what are they making of it and what does it do for their motivation? And of course, the truly traumatised just don't want to engage in a room full of people, and particularly if there are men present, because some women bring their partners along. And we're all aware of those justice social work reports with the headline saying, please do not reveal this in public. That's a regular occurrence in this court. Great care is needed. I will often be speaking in code. As I say, I'm trying to build up a relationship with that individual. And it's also a very evolving picture, and the pre-court social work meetings give me that intel as to what is going on in somebody's life in a way that becomes really essential when you understand the vulnerability of the cohorts that I'm dealing with. When they turn up with their partners, it's helpful to have the background knowledge as to whether that's deemed to be a positive or a negative influence, I'm sure you can appreciate. And also the loading of the court has been a historic issue, which I think we've managed to get a bit more under control. At the beginning, I would regularly see 30 or 40 women in the court in an afternoon. And after 5 o'clock, they would be just so anxious and overloaded that they would just leave. So that became an issue. So it's about striking a balance between gaining trust, but maintaining that edge to nudge compliance and cooperation. Does that work? Well, there is research that's been commissioned by Glasgow City Council. It's underway now into the operation of the court, which I really welcome. And opportunities like this as well to share experiences and to identify insights and good practice is enormously helpful. In terms of carrot and stick, quite often I have a woman before me with 10 charge sheets, maybe you call them, and 10 complaints, and maybe lots of them will be those failures to appear at court that become standalone charges. My contract with them, if I can describe it thus, is to admonish a few at a time. If they cooperate, they can see the number of cases that are live just diminish when they show me that they are complying. And it was reported back to me that one girl felt that really mattered, and it got her buy-in that was otherwise proving difficult. And another issue is which problem-solving court suits best. And I thought that was interesting with the example that we heard from Julian about the medical student. I would not see her as being a candidate for the women's court. I would imagine that she would be able to cooperate with any mainstream court, deferred sentence or supervision via a community payback order. There are no women at all currently on the roll of the drug court in Glasgow, and because testing can be done at Tomorrow's Women, but really, is it the right environment for everyone? These are the discussions that I have with my Shreveport colleagues all the time. And as I deal with indictment matters, that's the serious crime, heard before a jury here in Scotland, I can see really serious offences, and it can be a real mindset challenge to accept that this person merits an opportunity to be placed on a structured deferred sentence as an alternative to a long custodial sentence, which a male accused would receive without hesitation. So some of the things that I wrestle with, any thoughts welcome. Thank you very much. That's all I was going to say.
Thank you so much, Sheriff Gilroy. Right, and so over to our last speaker now, Sandy.
Hi, thank you. Yeah, I'll try not to be too boring on the graveyard shift, but yeah, I just wanted to give a brief overview from more of a practitioner's point of view about the operation of a team within the police and the criminal justice system using deferred sentencing. So I won't go into too much detail of time, but it's been a very long, difficult road to get to a point where we're able to operate out of any Crown Court site within the Midlands in front of any judge, basically. And it's a completely transformative way of managing and controlling what we would call neighbourhood crime, so residential burglary, commercial burglary, theft, vehicle crime, that sort of thing. I've got a team of dedicated staff who do this as a full-time role. And we've shown that this type of problem-solving approach is kind of key to running alongside other more traditional catch and convict operations. We're dealing with the most prolific offenders, talking about hundreds of criminal offences, and really completely changing what they've experienced in the past to break them free from that just continuous cycle of crime. And without that deferred sentence period, I can probably quite confidently say we would not be able to manage that. So the process really is quite straightforward. Persons are charged, most often remanded into custody. We will screen those individuals, look at their past. So we've got a sort of very simple matrix of qualification that we'll look at to make sure they're not extremely violent or extremely dangerous, and that effectively mostly in the main sort of drug addicted offenders using theft as a means to source that addiction. So we'll go and speak to that person, speak to them in prison, often with their legal teams as well, and sort of assess what they want to do. And a lot of the time they'll be saying, oh, I've had enough of this, you know, I want to change, the usual type of stuff we might have heard in the past. And our response will be very simple. It'd be, well, prove it. And we are able to then use deferred sentencing to design a plan specifically for that individual, whereby we can come up with a list of conditions that we will present with probation and the CPS to the judge, to show how we're going to control that individual, how we're going to manage the risk, and how we're then going to solve the problem, whether it's through a specific drug treatment, whether it's through enhanced restorative justice, housing, rehab centres, so forth. It's very, very individual to that person's problem and to that person's plan. Now, the benefit of where we are now is the judges can be very clear on what's going to happen. There was a bit of a cloud of mystery in the past, we found, with some of the judges, where they felt if they gave a deferred sentence, they were kind of implying what the result was going to be months in advance, almost like it came with some type of promise. We can be very clear now that under the Sentencing Act, if you follow those conditions and show that you can follow those conditions, this is likely the outcome. We work towards community orders, basically. If you don't follow those conditions, custody remains an option for you. So the sheriff mentioned Damocles' sword is a really good example of exactly that, they've got to basically show, and as Julian said as well, it's an incentivized process where they've got to show and put the effort in to be able to get the outcome that they want to get to. And that will often be a sort of 2 or 3 year community order. So that's kind of the very practical process that we undertake. And the use of deferred sentencing for me has some very, very clear benefits. There's massive benefits in terms of restorative justice. Just from a practical viewpoint, it's not particularly easy to get into the prisons to speak to people. It's not particularly easy to engage with defendants when they're on remand. They don't often want to speak to police officers or anyone when they're in jail, and they're getting used to life within jail. By bringing them out of that environment, it's much, much easier to work with them. We're lucky here within the West Midlands that we've got a charity called Remedy who have professionalised that restorative justice process. So we're able to speak to victims in advance. And as part of our deferred sentence plan, which is a document we give to probation 2-3 weeks in advance of the hearing, we can name, right, the defendant will meet this victim on this date, on this date, and on this date. Those sessions are going to be filmed, and this is what's going to take place. So we're able to give definitive dates and times when those people will meet. It's quite a powerful experience for those victims. Sentencing, I know we see it in the press, but from a policing point of view, sentencing is very scientific sometimes, as it needs to be, with discussion and argument over where things sit at what level. Victims, it's sometimes difficult for us to sort of get them involved in that, but through restorative justice, they can feel slightly, they've got more of a say, they're quite empowered. So, you know, we're offering an alternative to an immediate custodial. We ask those victims, well, what's your thoughts on this? Do you agree with it? Do you not agree with it? And the amount of empathy these victims will show, like, well, if I can do something that might stop this person doing to me to someone else, then I want to do that. So by meeting that individual, will that dissuade them from committing that crime type again? Yes, most of the time it does. So that really empowers those victims. That then gives them a great sense of satisfaction. They feel that they've had quite a positive engagement with both the police and the courts. And then that increases their confidence in the system overall. They've been a victim. They've taken part in this process. They're contributing to solving the problem, as we all are. We're not passing a problem anymore. Police would pass the problem to the courts pass it to the prisons. We're working together on a common ground to solve the issue together, because we all have benefit from solving a problem rather than passing it from one agency to the next. And the reparation part of that, you know, when they're coming out on these deferred sentences, they're telling us huge amounts of information, talking about huge amounts of crime we have no idea about, that they want to talk about formally in the form of a TIC to bring closure to those victims, tell them why they did it. People will think they've been targeted for a specific reason, but they haven't. It's often just for this and this reason, and we tell them that. We've had examples of cases, sometimes young people who've had severe bereavements, losses of parents, trauma, and that's just pushed them into crime. And once they've gone into that prison system, sometimes it's very difficult to pull them out. So we've been able to put a plan together with the victims to sort of stop that individual doing that type of thing. But I think for me, one of the real key parts of this, when we design our deferred sentence period, I want it to mirror what that community order is going to look like. So we put my staff go down as the responsible officers on that order. So the judge is confident that there is a dedicated resource given to this case. If we're standing in court and saying we're going to deliver something, we are. It's not just going to get sucked into other demand. This is what we're going to do, and this is how long we're going to do it for. And this is the plan on how we intend to achieve that. We are effectively coaching that individual, that defendant, on what they need to expect when they're given an order. So we're almost taming the horse as it comes out of jail, and they come out and they test the water. They want to do silly things. They want to do this, they want to do that. And it's like, you're just not going to manage that within this system. You'll see this person every day, probably for the next 4 months minimum, and this is the expectation around how this is going to work. And it's clear in their head then that there's no movement. We've got GPS technology to help us track what's going on. We've got all these plans laid out, and effectively, we've got rid of all the tripping points that would provide them for excuses as to why these things couldn't be achieved before. So that coaching is really, really, really key to making sure that by the time they go back to court and we can give those updates to the judges and probation and the partner agencies, they're satisfied that they can maintain a tag, they can answer the phone. And that sounds really simplistic, but these are the things that they put them back in prison. They won't take drugs, they won't commit crime, they will abide by a curfew, and they'll stay inside an address. So once they're able to show and demonstrate at a practical, common sense level that trust can be given to them to do this in the community, then it just opens up so many doors for them: employment, training, voluntary work, all types of stuff. So that's kind of, from a very practical point of view, what we do. The new guidelines coming out has been a total game changer. The judges are really, really grateful of the sort of clear flowcharts and the clear process that's going to be there. It's kind of got rid of a lot of worry, particularly with some leadership judges around whether they could or could not do it. But I've got to say, they've all been very, very supportive, really good. And we're doing at least 2 cases a month now across a metropolitan force, and we're seeing in some crime types reductions of 6,000-7,000 offences now, as we sort of tie this into a longer term strategy going back to sort of 2019. So we're hoping to expand it. I've only got sort of 9 or 10 people working on it at the moment, but we've kind of proven at a very practical level that it works. So if we can promote that and help others to do that, that is our objective. And I can see Claire's on the screen now, so I think I'm out of time.
Thank you so much, Sandy. That was great. Yeah, so we've got just sort of 8 minutes now for questions, so I'll try and get through as many as I can. So if Julian and Judge Gilroy, you're available. I know Sheriff Gilroy that you might have to go, but let's see what ones we can get through for now. So we've got an email from someone, a question that someone says they can see the benefits. So this is for you, Julian, I think. They can see the benefits of deferral, but I can't see how it would be any different to the court simply issuing a suspended sentence order instead of deferring the sentence, in which they would do all the things that a period of deferment would have allowed, but means they don't have a 6-month delay in their penalty.
Yes, can you hear me?
Yes.
Yeah, no, well, it's a very good question, and a number of people have said, well, look, why not just use a community order? You can impose these requirements, and in the event that there's non-compliance with the requirements, and the court can react. A suspended sentence order is a term of imprisonment. The custodial threshold must be passed before that the court may impose that. So what you'd be looking at in the case of deferral would be an offender who is facing an immediate prison term, or even a relatively lengthy suspended sentence order, which may go up to 3 years according to the new legislation. And if they make significant progress, the court may wish to impose instead a community order with additional requirements. And so one response to this observation would be that, it avoids a prison sentence. And I'm considering, as is the case in law, a suspended sentence order to be a term of imprisonment.
Great, thank you, Julian. So we've got a question as well from Luke. So he works for Change Grow Live, a drug alcohol service, and part of their role is overseeing alcohol treatment requirements and drug rehabilitation requirements in the area. So can community sentences such as these, sentences such as these, be given as part of a deferred sentence? So I don't know who wants to take that one. I mean, I guess that's kind of how it works, doesn't it, in the problem-solving court, Sheriff Gilroy? Sorry, I've got you on mute.
I can make a quick mention on that.
Oh, thank you, Sandy. Sorry, Sheriff.
Because they're not technically sentenced at that point, it becomes an issue with funding sometimes. So what we can do is make it a requirement of their order for, say, field testing, that type of thing. But we personally can't impose sort of DR requirements at the point of deferment because they're not sentenced, so the funding isn't there for that agency to necessarily pick that up. But we kind of work around that through coming up with a cohesive plan with them. There might be some funding for those field tests to be shared amongst the agencies. We might still be able to bring them in for drugs testing via probation. A lot of times defendants will have orders that are sitting in the background or licenses that allow us to bring them in, and then when they're in with probation they have to be tested as well. So it's very case dependent, but a formal order for drugs testing we can't do till they get their community order.
Great, thank you, Sandy. And then we've got a question from Colin. So I think, Sheriff, you might be able to unmute if you do it yourself. I think maybe something can kind of happen. So Colin supports ex-military veterans in the justice system, and he believes that they would greatly benefit from the increased use of deferred sentencing, and he'd appreciate any sort of advice from the panel and how they might approach this.
So I missed that. What was the question?
So it's Colin supports ex-military veterans in the justice system, and he believes that they would greatly benefit from the increased use of deferred sentencing. And if there's any advice from the panel how to sort of approach this. Have you had many veterans go through your schemes, Dandy?
No, and this sort of comes back to the first question around why we don't just go straight to orders and so forth. And you hear legal expressions of grasping the nettle and just getting it done straight away. But I just think it's worth investing that little bit of time at the start to really try, like Julian said, to avoid custody. So if there's there isn't like an ex-offender cohort within sort of a charging process where that's going through, it might be that if there's charities working with ex-offenders in whatever borough they are, and they want to speak to their sort of local police force. We have had some ex-military come through, but they just came through as sort of standard defendants, but we were aware of their background and some of the specific needs they'd have. There isn't a specific group that we would categorise as ex-military, no. Yeah,
thanks, Andy. And Sheriff Gilroy, I know that obviously in the women's court it might not be sort of as common, but I can imagine it's quite common in the drug and alcohol courts that run in Glasgow, that are veteran sort of clients. Is that?
Certainly, I've seen offenders with a background in the military of whatever nature, and you know, it can be that I think that the entry point for me with all of this would be the report that's prepared for court by social work. And their solicitor standing before the court saying, well, I can tell you that there is an issue with alcohol or with drugs. That's the background to this offending. And our social workers have a template that they must follow whereby all of these sentencing options and the opportunities that any of the problem-solving courts might provide would have to be rehearsed in the report.
Great, thank you. And I guess we've got time for one more question. So Kirsty asked, how can these approaches be used to improve the outcomes of women in contact with the criminal justice system during pregnancy or while they're caring for young infants? I guess that period of deferment will give you sort of that time to work with them. Are there women that come through your court, Sheriff?
Yes,
yeah,
very much so.
Yeah.
I'm frequently told that, in fact, it will quite often happen that nobody knows they're pregnant. I'll be given that information and they don't want other people to know. So that's one of those coded conversations that I could be having with them. And I'll be interested, though, to receive behind the scenes information about due dates so that I can then plan and program and know what's likely to be coming down the track.
Great, thank you, Sheriff. And I guess that fits as well with Julian, what you were saying about those other circumstances that might be apparent in a person's life for a deferred sentence. It's not just the courses or the education or drug and alcohol treatment. It can be things such as pregnancy or childcare.
Absolutely. I mean, it's a scandal that there are people giving birth in prison, or for pregnant women being committed to custody. It's rare, but it does happen, and there's absolutely no excuse for it when you have the deferral power.
Yeah. Great, thank you, Julie. So we've got 1 minute left, so I'll call it for a close today. There's a few questions still in the Q&A, so what I might do is send them to the speakers separately to get some feedback and share those with those who have asked them, but I think we got sort of most of them. So just want to again say a big thank you to the speakers, so to Sandy, Sheriff Gilroy and Julian. I thought your presentations were a great sort of summary of what's happening, but also what's worked, what sometimes you need a bit more thought around, but hopefully it will sort of encourage people to think about deferred sentences more in the work they do. The recording will be available on our YouTube of this event, and you can sign up to our newsletter and follow us on social media, both which you'll find details of in the Q&A. And there is where we post more details about expert voices that are coming up. So yes, a big thank you to everyone and those who have attended and asked questions today. So we'll just call the session to a close. So thank you, everyone.
Thank
you very much.
Bye.
Bye.